Welcome everyone, you're in the right place. This is our virtual roundtable on intellectual property. This is a session that we had originally scheduled to hold in person a couple months back, and it was a bad weather day, so I appreciate everyone's flexibility and welcome you to our conversation today. My name is Joanne Geer, and I am the Executive Director for the Westchester Biotech Project. We are an organization based in Westchester County, New York, and really are developing national and international collaborations that help to bring researchers, engineers, and data scientists in our region into contact with professionals around the world. I will just share a bit of excitement if you're not in the Westchester area. Just about 10 days ago, a press release, a lease was signed for a $1.2 billion life science research park in Westchester. It's called the North 60, euphemistically, and it'll take a few years, 2 or 3 years to, get all the engineering cooking, and to probably 3 to 4 years to get a building up. But what's exciting about it is that we are part of the cohort of organizations, companies, hospitals, and so on that are moving this forward. So you'll be hearing a lot more about it, and the piece that we are really leading the charge on is to build something we're calling an enterprise center. So there are incubators in Westchester for life science companies. Obviously, there are many incubators in New York City. And these companies, when they're ready to leave incubators, need a place to go. And so we are working on developing a center that will have some elements of the incubators and accelerators, and really be designed for a company to grow, not from 1 to 2 employees, but from a handful of employees up to dozens, with some flexibility and shared resources and all kinds of really, it's exciting what this can become. So we welcome everyone on the journey, and we'll be sharing information about that ongoing. Just a little bit about our programs. So we have programs and we have initiatives. So our innovation and research is our annual conference that brings together researchers across the region, as well as business people who are interested in the life sciences and in building the biotech cluster. And we've just booked the date, which is March 27. And we will be sharing a lot more about that with you, and we will be posting a call for abstracts and registration and so on. So please keep an eye out for that. We just signed an MOU for Westchester Biotech Project Europe, which is a really interesting cohort based in France. Includes lots of different major pharma companies as well as growing companies. And what I love about this is we've been working with it, and we will definitely have a session soon to invite people to learn a lot more about it. But in Europe, there are a number of great facilities, and but they don't know so much about how to collaborate. We have a dearth of facilities, and we're really good collaborators. So we're really looking forward to positive, and it's kind of a sister city relationship to start, but it could really grow into something much more major. Our Young Investigators program focuses on early career scientists, so from that sort of PhD postdoc era through around age 40. It's the part they call the leaky pipeline. So we definitely would work very closely with colleges and STEM programs. We support K-12 programs, but our focus is on those early stage scientists. It's not easy to become a scientist, and it's harder to remain one. So we have some interesting programs for that group. We are part of the development of a rare disease research hub in the region. And so we have held one symposium, which was last summer, and we'll be doing it again this summer. It's a really great opportunity, especially with our connection to Europe, to develop a soft landing for international researchers to come to the US. And then our consortium on translational research in the microbiome is really interesting. This is looking at enabling technologies and issues around developing standards and so on. So it's the wild, wild west, and we're part of a community including NIST and other major parties, ATCC, and that's a collaboration with the Institute for Life Science Entrepreneurship at Kean University. So that's just a sampling, and we'll always invite you to poke around our website, and I'm happy to tell you more about any of it. We have a lot of friends and collaborators. Some of them are financial supporters. Some of them are alliance partners where we're seeking ways to collaborate, and we haven't quite figured it out yet. So you can see our door is open. I'm going to hand things over to Chris Palermo from Harris Beach, and he's going to introduce our speakers today. What we'll be doing, I'll let you go ahead with the transition. Today we will hear two 15-minute presentations, first Scott Locke and then Laura Smalley. And then we'll have a chance for people on the call to introduce yourselves and one at a time and talk about what's been brought up in the presentations and see where the conversation goes. Thank you so much. Chris Palermo, take it away.
Thanks very much, Joanne, and welcome everybody. My name is Chris Palermo. I'm a senior counsel at Harris Beach in the firm's litigation group, and based in the firm's office in White Plains, where we are very excited about the North 60 lease that Joanne mentioned. I am co-chair of the Intellectual Property Roundtable of the Westchester Biotech Project, and my practice over the last 15 years has involved representing pharma companies in a wide variety of litigation matters and government investigations, including antitrust and intellectual property, drug pricing issues, and product liability issues. So today, digital innovation in the biotechnology industry, data analytics, management and manipulation of data, creation of code for bioinformatics, personalized medicine, and the creation of apps. There's a lot of exciting things going on in this space. And so we're here today to talk a little bit about how to protect and capitalize on those assets, particularly in light of the recent trends in U.S. patent law narrowing the types of inventions that are eligible for patent protection. So the way we've structured this is that first Scott is going to address intellectual property issues outside of the patent area, and then Laura will discuss patent issues. So I will introduce Scott. Scott Locke is a partner at Dorf and Nelson in Rye, New York, in Westchester. Scott is the chair of the firm's intellectual property practices group and is also with me the co-chair of the intellectual property roundtables of the Westchester Biotechnology organization. Scott's practice focuses on counseling startup, small, and growing companies on protection and use of their intellectual property rights across diverse areas, including biotechnology, pharmaceuticals, gene therapy, data analytics, bioinformatics technologies, and medical devices. Scott is admitted to practice before the United States Patent and Trademark Office and has a technical background in biology. So without further ado, I'll turn it over to you, Scott.
Hey, thanks, John, and thanks, Chris, for the introduction. And let's jump right in. Is my slide moving?
Not yet. Usually if you click in it, it'll catch up to you.
Okay, here we go. Let's jump right in. So today, as Chris mentioned, we're going to focus on the businesses that tap into that synergy between biology and computing sciences and data analytics that's really only become possible through the cloud and the great power that the new computing technologies have. Now, today, I'm going to start at the end and discuss a little bit first what your competitors and what the investors are going to look at when they see businesses in these fields. And the two really brass rings here, for my purposes, are the code you have, your computer programs, whether it's your source code, your object code, and the data and the databases you have. That's what's going to be primary value. But there's also some secondary things that you want to think about because they are really valuable assets at times. And those are the first group being your methodologies, your algorithms and your analytic techniques, which Laura's going to speak to in a few minutes. But you also have your agreements and your relationships. Think of any exclusive licenses you have, arrangements you have, particularly with universities and professors, and then things like your digital images, your graphics, other issues relating to how you present to the world. Because your competitors and investors are always going to think, what's the scope of the intellectual property you have, what type of exclusivity you have, and how much have you buttoned up your ownership? With that framework in mind, let's jump in a little into the types of intellectual property. On this slide, you'll see there's a great quote from Mark Getty that intellectual property is the oil of the 21st century. And on the one hand, he's right, because that's what most of the value in most companies is, except it's important to note that IP is not a commodity. It's more like snowflakes. No two are really alike. And different assets you have are going to require different means for protection. And just kind of working counterclockwise around the slide, you have your patent protection, the upper left, your trade secret protection, those technological safeguards that you put in, your passwords, your firewalls. In the old days, it would be fences around your property, the agreements you have, your NDAs, your copyright rights, and last but still important are those incentives that you give to your employees and your contractors, be it stock or other financial incentives. We're going to start by going deeply, and most of the talk will be about what copyright law means for businesses in this industry. And here it's the only other quote that I have. It's a great one from Mark Twain. That the copyright law, it's really not quite so intuitive, and Congress has tried a number of times to address it in the context of the computer industry and really done it fairly poorly. If you watched the Senate hearings a few weeks ago, you saw the senators didn't know the difference between Google and Apple and their iPhone products. That kind of carries through the law, so it's still very unsettled, but it's one that you're going to have to know how to navigate. So to get us all on the same page with a little copyright primer, it's important to know that copyright rights protect the expression of an idea, not the idea itself. So it's how your computer program is written, not the idea that you've got a computer program to manage data. And computer code is copyrightable. It is protected by the copyright law. So are the graphics that you create, the apps you develop. One thing that is not protected by copyright law is data. How you arrange your data is protectable, but the data itself is not protected by copyright law. So you have to think about other means to protect your data from third parties who want to use it. And those are sometimes the technological safeguards that we have. And what copyright protects you against is that unauthorized copying of your computer program, of your data sets, your databases as they're organized, and the creation of new works from those data sets or computer programs. And the great thing about copyright law, your rights are long. They last 70 years past the author's death, or 95 years if it's a work for hire. So they are really long in duration, but unless you're Disney or Salinger or Fitzgerald, it's not really so important the end years, because particularly for computer programs, by the end years, the field has moved on so far that the copyright rights aren't important from a commercial point of view. As you work with your copyright rights, two things to keep in mind about the process. You get copyright rights as soon as you create something that's original and you memorialize it or write it down. You do not have to register copyright rights to have them. Registration gets you into court and it gets you certain benefits in terms of damages, but you still have those rights, which is great for you. But remember, third parties have those rights as well, even if they don't register them. The other important myth to dispel is you do not need a copyright notice. So you'll see that none of these slides have a copyright notice. There's no little C in a circle or the date or my name on the bottom of the footer, because it's not necessary. I have the copyright right in my slides by the virtue of my creating them. So as you're working these businesses, it's important to keep in mind some of the limits on the copyright rights that you have. The facts that you create, as we discussed, are not protectable. Medical records are not protected by copyright rights. Medical images are not protected by copyright rights. They're deemed not sufficiently original. A compilation of them might be because you're doing something creative in how you select and organize them, but the individual images, your X-rays or the higher level images people are doing now, are not protectable under this doctrine. Things that are independently created are also outside of copyright, so if someone else comes up with the same type of program and does it in a clean room, then you have no copyright cause of action against them. And this is why people do use clean rooms. It's a defense to any copyright infringement because you haven't actually copied. You couldn't. You did it in a clean setting. Your functional features are also things that are not protected by copyright law. So if you think a DNA sequence, if you write it down, is functional, it's not protected by the copyright. So as you're thinking about your copyright rights, it's important to delve deeper into what is permissible. And on the left are a couple of the easy cases that Congress dealt with. You know, it's not a copyright violation to make a copy of a program you need to make it run or to fix something on your computer. You know, those are reasonable things to do. There's a doctrine in the copyright law called the fair use doctrine, which is codified, and it allows certain exemptions from liability because you've done something that kind of furthers the purpose of copyright and you're not really competing. This is another area where there are a lot of myths about what makes something fair use. Something's not fair use because it's not likely to be caught, or you think it's too small, or you just think it's really a good idea to use it. It's really narrow and very fact specific. So I always counsel clients, don't rely on the fair use doctrine too much. If you're a Generation X person or older, you'll recognize the picture on the lower left-hand side. Those are cartridges from the Atari 2600 that we used back in the 70s and 80s. There's a whole lot of case law about computer games and how people try to make their cartridges compatible with other people's games. And there's big litigation between Atari and Nintendo back then. And there are certain things that you can do to make things compatible with other people's programs that aren't copyright violations. The problem is that when most people try to do that, they take too much and they end up exposing themselves to liability here. So this general setting for the copyright world that, you know, code is protectable, data is not, but the organization is, you can disassemble certain things, is where we are January 24th, 2019. Tomorrow is the deadline for Google to appeal the case that it has against Oracle. And if you've been following that case, Google used Java, which was created by Sun, and opted not to take a license. Oracle bought Sun. It's a lot more litigious than Sun was, and it sued Google. It sued Google in California. Google wins, saying that the declarations in Java are not copyright protected. Google has to appeal to the Federal Circuit in Washington. It doesn't get to stay in the Ninth Circuit because there were some patent cases, claims involved, and Google loses on appeal. It goes back down. Google says, you know what, okay, they're copyrightable, but what I did was fair use. It wasn't so much. It was part functional. Google wins again. They appeal again. They lose again. So Oracle has now won twice on appeal, and tomorrow Google has to file for certiorari with the Supreme Court. This is a case to keep an eye on because it has the potential to shift the landscape for copyright protection. It's likely to be a very big decision. I'm not sure if it's going to come down this June or the next June, but it's one to be mindful of. As you're working and developing your businesses, a couple of key points as you work with your programmers. They will routinely sign non-disclosure agreements. Most of them are fairly standard. You know, the provisions aren't that difficult. The thing to be wary of is that a non-disclosure agreement only buys you a lawsuit against somebody who breaches it. Once the information is disclosed, you can't pull it back. So it becomes very difficult. So you always want to know who you're dealing with and not rely too heavily just on the contracts. Works made for hire, we mentioned them a few minutes ago. A lot of people like to title their agreements with independent contractors as works made for hire. It doesn't become a work made for hire just because you call it that. There are certain statutory requirements to do it. The benefit of being a work made for hire is that the person who pays for it automatically owns it, but you don't get to do that with your independent contractors. You need them to execute assignments, which you want to put in any independent contractor agreement you have with them. In those agreements, you also want to make sure you get access to all of the code, all of the passwords, so when your independent contractor walks away or your time with her is done, you still have the rights and access to everything you've paid for. A few ownership pitfalls to keep in mind as you're working with code and data is as you're starting out, frequently your independent contractors will have day jobs. You need to be mindful of what their current or previous employers already own. A lot of them have certain policies if work is done related to their day job or if it's on their computers, they have some ownership rights and you don't want to find that out too far down the road. That's something you want to know up front. Open source, that's the code that's generally easily available on the web. You can get it downloaded, and you just agree that you're not going to do certain things with it in terms of making it secret. There are a lot of different open source licenses. A couple of things to keep in mind: the agreements you make to get access to the open source are binding on you, even though it's just a click through. Those are enforceable in court, and if you violate it, then you can get exposure to copyright liability. Also, investors like to know what you've used and incorporated that was open source, so you're going to want to track it. When you're working with your contractors and you're doing it and you get started and you're really excited and you just want to get the project going, often there's a temptation not to have the contract executed and kind of do a handshake. This is the adage, good fences make good neighbors. You really need to get everything down and delineated in writing first, because when things go sour before an agreement is signed, the independent contractor is still going to own what he or she created. The default is that the creator owns it, not you. Crowdsourcing. There's a temptation to do crowdsourcing, to get easy solutions from around the globe. Be wary that's going to create a lot of problems in terms of ownership. So if you can avoid crowdsourcing for something that's going to be valuable to your company, I do recommend that you do that. Going to shift gears again a little bit to some trade secret ideas. And everybody knows the most famous trade secret. It's the Coke formula. It's locked in a vault in Atlanta. Only 3 people can gain access to it. I don't know how much it's urban myth and why people can't figure out how to reverse engineer it, but that's the greatest trade secret that people know of. The danger with trade secret, or the risk, is that not everything that you want to keep a secret can qualify as a trade secret. You have to jump through certain hurdles, and they're listed on the slide. The information can't generally be known. It's got a value because it's a secret, and you've got to have taken steps to keep it a secret. These rights are enforceable in court, and you can get injunctions, and there's new legislation that was issued just 2 years ago, the Defend Trade Secrets Act, and a lot of people are doing it. However, again, that's a cost, so it's another time, just like the NDAs, that you want to be careful with who you work. When we're talking about your trade secrets, your biggest risks are actually going to be your former employees. That's who most often breaches, so you need to be cognizant of how you incentivize them to keep secrets and be mindful of where they're going. On a practical level, people do this through exit interviews. They give them a certain bonus or severance, not to go for competitors or to keep things confidential. You can, again, get preliminary injunctions against them, but you always want to avoid the problem. If you've heard about the Pinterest issue that happened, this is kind of the best evidence of the dangers of relying on trade secret protection and trying to enforce against it. Everybody's probably familiar with Pinterest. Way back in 2005, a few law students who admittedly don't necessarily make the best plaintiffs always came up with an idea for a social networking platform to let people know where they're located, geolocation. They revised it in 2006 to expand, to let people express their interests. They go and pitch some investors. One of the money guys says, you know what, I think I'm going to pair up with you. They form a new company with him. And despite the fact the money guy has experience and they were law students, nobody really papers over who owns what and what happens when they break up. And naturally, things dissolve. They all kind of go their separate ways with the company in force. And the money guy comes back and says, you know what, I found some new guys to work with. They've got a different kind of e-commerce site, but that e-commerce site evolves into Pinterest. The original law students come back and say, you know what, you misappropriated my ideas, you stole my trade secrets, you breached my fiduciary duty. I want a cut of Pinterest. Unfortunately for the law students, they didn't follow through on the obligations of trade secrets. They didn't define what they had. They didn't have agreements in place as to who owned what, and they had no recourse. On this next slide, we start talking about data privacy. And it's a really crowded slide because it is a complex web of obligations. And it's one of the few areas where there's really a race to the top in terms of protection, not a race to the bottom. Last summer, California enacted its Consumer Privacy Act, which set the highest standard in the US for data privacy. It's going to take effect, or it's scheduled January 1st, 2020. Nobody really expects it to go into effect. They expect it to be revised, but it's a signal that there's going to be higher protection. And a couple of things to keep in mind is that this protection is likely going to be like the GDPR in Europe, which is currently in effect, requiring opt-in to use data. Two interesting things about California is you've got to give people equal service, even if they opt out. You have a right to opt out of selling of your own information. So there's going to be a lot of new burdens for companies that use data from their clients. GDPR earlier this week just issued its first big fine to Google for $50 million because it didn't comply with its regulations of disclosing clearly how it was going to use their data. I don't know if Google's going to appeal or what they're going to do with that, but those fines can be onerous. So if you have any European person's data in your data set, you have to comply with the GDPR, even if you're located in the US. Cybersecurity is something you're all familiar with. Most people will just contract that out. And HIPAA, of course, everybody on the phone is probably vastly familiar with it. In all of these, though, there are certain methods for when you de-identify data, so you can't figure out who the individual is, that you can use that data for data mining. It does lose some value that way, but there is a procedure for you to be able to grow your business on the anonymized data. Unfortunately, the different regimes have different standards of when you can use pseudonymous data. That's data that doesn't identify a person specifically, but you could get back to that person somehow if you had the key. So again, you need to be careful where you get your data from, what kind of consent you have. All right, the last issue just to toggle through is as you're working on the internet and with the internet, a couple of IP issues to remember, or rules of thumb. Just because it's publicly accessible on the web doesn't mean it's publicly available to you, so you need to be careful. The default is people have copyright rights. You can go to websites to get images, which is what I do for the presentation, where people have said you can have free use. There's no copyright issue, or you can pay to license certain images. We didn't touch upon trademarks very much, but as you think about your trademarks, just remember the Trademark Office and GoDaddy are not related at all. So registering a domain name is not the same as registering a trademark. In terms of directing people to your websites, if you're having a website business, and search engine optimization, Google AdWords you can use. People do use other people's trademarks to direct traffic to them. There are ways to do that without violating their trademark rights. Finally, as you're developing your apps and your websites, one thing to keep in mind is that you can get what we call trade dress rights, which is kind of the look and feel of the website, of the app, as long as you're consistent throughout. Those are difficult to get, but you want to be mindful of some type of consistency so that should somebody try and benefit from your goodwill and they try and make it look too similar, you do have rights against them. Chris, I'm going to turn it back to you.
Great. Thanks very much, Scott. And as we said earlier, we will open the floor for discussion after Laura's presentation. And now we're going to turn to that, and Laura's going to address patent issues. So I will let me introduce Laura. Laura is a partner at Harris Beach, a colleague of mine. Laura practices in the intellectual property, business and commercial litigation, and appellate practice groups here at Harris Beach. She has been selected as one of the best lawyers in America. She focuses her legal practice on technology development and exploitation, including the enforcement of intellectual property rights. She also prosecutes patents in the chemical and biochemistry fields. Laura is admitted to practice before the United States Patent and Trademark Office and has a technical background in chemistry, including organic and analytical chemistry. Laura has litigated several patent infringement suits, including medical devices, electrical components, and consumer products. So without further ado, I'll turn it over to you, Laura.
Thanks, Chris, and thanks, Scott, for the good presentation. I'll be discussing patenting bioinformatic inventions, which is kind of an area fraught with confusion, mainly due to Supreme Court jurisprudence regarding the patentability of abstract ideas and laws of nature. And before starting, I kind of wanted to present a definition of bioinformatics, and I think basically it's understanding and organizing biological information using math, computer science, and statistics. There is a patent classification for bioinformatics. It's stuck under, at least in the international patent classification system, under physics. So you go to physics and then computing and keep going down, And then finally, in a subclass, you'll have bioinformatics, which includes, as you can see here, methods or systems for genetic or protein-related data processing in computational molecular biology. You can have modeling or simulation in systems biology, molecular structure, functional genomics or proteomics, gene expression or hybridization, including microarrays, sequencing, sequence comparison, and other types of things that are really the intersection of computing, analysis, and biology. It's because the class is kind of diverse and can have bioinformatics patents stuck in different areas that are not defined as bioinformatics. It's difficult to get a firm handle on how many bioinformatics patents there are. There was this study in 2017 showing an uptick, but then a little bit of a downtick in bioinformatics patents. There were actually some as early as 1977, and the number of applications seems to be increasing on average. The largest set of filings, despite difficulties in patenting, is the United States, but there are also significant patenting in Japan and China. And as of 2014, these were some of the biggest companies in terms of number of patents filed regarding bioinformatics. So there are companies that are fairly large stakeholders in this area. And basically, as I alluded to before, the biggest issue in patenting bioinformatics patents is whether they constitute patentable subject matter. So generally, you can patent new and useful processes, machines, manufacturers, or compositions of matter. And really, bioinformatics is a process generally. So it's an act or series of acts or steps, because you're gathering information, analyzing it, and then sometimes acting on it. And one reason that Scott's talk was important is that the databases themselves are generally not patentable under current U.S. law. So the information that you've gathered through whatever bioinformatics techniques you're using, generally the raw information is not patentable. And there's a number of valuable, databases. For example, Myriad is supposed to have a huge database of breast cancer genetic variants that makes its testing more effective, because it can identify definitive findings for example, breast cancer and what mutations you have. But that's not patentable. It's what they've gathered over numerous years and millions of tests. And basically, there have always been judicial exceptions to patentability, but they were kind of resurrected in 2010 and started becoming more of a force in the patent area. So basically, you cannot patent laws of nature, abstract ideas, or natural phenomena. And when you're looking at a method like bioinformatics, like comparing sequences or analyzing biological data, one of the issues is whether it's simply an abstract idea. And at the current time, you cannot limit the abstract idea to a field of use or add token post-solution activity, for example, like administering a vaccine after you've analyzed whether someone's at risk for a disease. That's viewed as an end run around not being able to patent laws of nature. For example, this isn't necessarily bioinformatics, but I think it's a useful case, is the correlation between blood levels of a certain substance and the dosage of a drug is an unpatentable law of nature because it's a consequence of the ways in which the compounds are metabolized by the body. And that was considered basically a law of nature and not patentable. So when you have, for example, a natural process like what your body does when it takes certain drugs, or how a molecule reacts, that kind of thing, unless you have novel elements surrounding that, it's not patentable. So, for example, administering something by an injection, scanning data are all well understood routine conventional activities that cannot lend patentability to a natural process or an abstract idea. And basically, when you're going to the patent office, right now the patent office has guidance on how to analyze analyze claims to determine whether they're patent eligible. And just so you know, there has been clarification or guidance that is still under comment issued by the patent office that might clarify these rules. Right now, even though the patent office has kind of taken case law and has this nice flow chart with a test, the devil's really in the details in determining what's an abstract idea, what's a law of nature, and whether a claim is directed to a law of nature. So here, usually there's very few things that are not a statutory category. So, as long as it's a process, a series of steps, what a computer's doing, or, a method of treatment, it'll meet step one. The issue is then going into whether what you're patenting is directed to a judicial exception. So is it an abstract idea, mathematical relationships, formulas? So algorithms are not patentable. So if you have developed an algorithm to analyze biological data, that in itself is not patentable. And as I said before, laws of nature and natural phenomena are not patentable. The Patent Office has a recent guidance will clarify, if it's adopted, that a claim is not directed to a judicial exception if the exception is integrated into a practical application of that exception, which is somewhat narrower than now. As I read it, a practical application could be immunizing someone after you determine whether they need it through analyzing biological data. But right now, the Patent Office will say, okay, if you're just analyzing whether someone needs more or less medication or needs a vaccination, are there additional elements claimed with the exception? So meaningful limits that will not allow someone to monopolize, for example, the relationship between a drug and metabolites in the body or genomic information. And the biggest area in bioinformatics is adding a limitation that is not well understood, routine, or conventional. So if there's a really novel way of analyzing the data, you could argue that, even though you're taking biological data, which is itself natural, and you're doing abstract things to it, which are mathematical, if you have very narrow and novel limitations on what you're claiming, you could be able to get a patent. So things like data gathering are generally not sufficient. So even if you're gathering the data in a novel manner, that might not be enough. So, going out and doing the assays or other things that are bringing the biological data into your system for analysis aren't generally enough. You can't also just restrict an abstract concept to a particular technological environment or field of use. So, for example, analyzing data from a genetic test to determine if someone has a condition isn't sufficient either, just because you're, having a specific field of use or specific use for it. And here's some examples: is an algorithm for calculating parameters indicating an abnormal condition is abstract. So, or comparing new and stored information and using rules to identify options. Those are abstract. So, a lot of methods of diagnosis, even if they're implemented in an app, and are really quite, novel and complicated, aren't necessarily patentable. And here are cases that might be, abrogated based on the Patent Office's guidance, or might be different. I guess the Patent Office can't overrule case law, but they might consider patentability differently. For example, the Klassen case involved a method whereby information on immunization schedules and the occurrence of chronic disease is screened and compared. And that was used to determine whether someone should be on a high-risk immunization schedule or a low-risk immunization schedule. And then the vaccine was administered. The Federal Circuit said that's abstract, and the only thing you're doing is administering a vaccine, which is routine. So that was not patentable. But the new guidance from the Patent Office indicates that that might be a practical application of what's an abstract idea or natural law. Improved methods of diagnosing Down syndrome by measuring biomarkers and ultrasound data, and then subjecting the data to multivariate analysis was also determined to be an abstract idea, because basically the biomarkers and ultrasound data were data gathering steps, and then the multivariate analysis was abstract. Comparing gene sequences is also considered abstract. So screening for breast cancer mutations by comparing the gene sequence with a standard was not patentable. Or a method for detecting a small fraction of paternally inherited CFS DNA in maternal plasma to determine fetal characteristics, even though the Federal Circuit Court recognized it was basically groundbreaking research. It was basically natural product in the body that was, subject to a data gathering step, and it was not patentable as a natural law, because the CFS DNA is in maternal plasma naturally. And I'll just leave us now with a sort of example. This patent here was not specifically in the bioinformatics category, but it is, an example of that type of invention. Basically, here's the steps. You produce a histogram of fluorescence intensity. You're detecting peaks of normal cells, obtaining the number of cells distributed in an area where the fluorescence intensity is stronger than normal cells, obtain the total cell number, and compare a ratio. So everything is really data gathering, and then using software and algorithms to compare data to reach a result. And basically, I think to try to get around some of this, the company claimed the device, a display, and a computer with a processor, and then the method of analysis. And then it separately tried to claim the method comprising measuring the data, detecting the peak, doing the computer analysis, and then determining the malignancy grade of cancer using that information. The patent examiner rejected the claim, saying it was basically directed to an abstract idea of determining the malignancy of a sample by analyzing the histogram, and that the additional elements in the claims were no more than a recitation of generic computer structure. They were routine and conventional, and that using the cytometric device was a data gathering step. So you see basically here, using the device, data gathering, using a computer to analyze is routine and conventional, and it's an abstract idea. And the PTAB, which is the Patent Trial and Appeal Board, reversed, finding that the claim was directed to an abstract idea of configuring a conventional processor to do the analysis at issue. But the examiner's rejection was unsupported because the steps of determining the malignancy grade by obtaining the number of strong area cells that were distributed in an area where the fluorescence intensity was stronger wasn't necessarily routine and conventional. So the PTAB looked at the method of analyzing the data and said, there's not enough evidence of the examiner's assertion that that's routine and conventional. So that's what you'll kind of want to look at. I still think you want to throw a physical structure in there, like whatever you're using to gather the data, but make it clear that, you know, what you're doing is novel and it's a narrowly defined claim.